Thompson. So a slight change to what is scheduled. Originally, my colleague was supposed to speak about European launch strategies, but unfortunately he couldn't be here. So I've changed the topic to the Unified Patent Court and unitary patent. It's a very topical issue, so hopefully you'll find it interesting. I'll try and speed up a little as well, because I know we're quite far behind, I think, now. So I'm just going to talk briefly about the history of the community patent and recent developments last year, how we go about obtaining the unitary patent and the translation requirements, some discussion on the proposed court structure and the jurisdictions of the various divisions, and then talk about the timescales, so when these new systems will be implemented, and the opting in and out provisions, as well as some strategies. So, as you all know, the EPC, the current system, has been very successful, but some criticisms are that it's very expensive to validate European-wide. The other problem is judgments on validity in different countries might vary from one European jurisdiction to the other. So in the past generation, so 40 years or so, there's been negotiation for a unitary patent and a community patent, but that has failed. Member states wouldn't ratify proposals and lots of problems with translation provisions. There was also some previous discussion, intergovernmental discussion, about a new unitary court, but that was proposed to be illegal under EU law by the ECJ. But last year, well, in early 2011 actually, the ECJ gave agreement for enhanced cooperation. So that is a mechanism by which a small group of countries within the EU could basically get together and begin the process for forming a unitary system. And from that, four pieces of legislation actually, which can be classified as the unitary patent regulation, so how the process for obtaining the patent, the language regulation, and also a treaty on the court agreement was agreed. Well, the ECJ gave agreement on that in early 2011, and the so-called unitary patent package was announced by Parliament late last year. As Mr. Dini already mentioned, Italy and Spain are challenging the language requirements, and as it stands, Italy and Spain are not going to be part of the unitary patent system. So at the moment, there are 25 European states, so when a unitary patent is granted in those states, it will be effective across all 25 countries. The unitary patent system will coexist with the current EPC. So there are different states. States that are members of the EU are not members of the EPC are not necessarily members of the EU. So validating a unitary patent won't necessarily cover all of the states which are members of the EPC. So the process. Well, the good news is that from filing the application and prosecution before the EPO won't change. The only change is at the validation stage. So when the drug exemplar, so-called, is issued, the applicant has to make a choice between whether he wants to validate via the usual route in the individual countries, or he can choose the unitary route, which will apply across all 25 member states. So, as I said, Switzerland, Norway, Italy and Spain will not be included in the unitary system because Switzerland and Norway are not part of the EU, and Spain and Italy are not participating. So the proposed costs are not yet fixed, but speculation is that the cost of validating for a European unitary patent will be about 5 times the average cost per country under the current system. As you know, you have to file claims if you prosecute the application for the EPO in English, you have to file claims translations into French and German to get the application to grant, and that isn't going to change. But where the language used before the EPO is German or French, then the whole specification will need to be translated into English. But if the application is prosecuted in English, then you do not necessarily have to translate into German or French. You can choose your language for some other state that's part of the EU that you wish to translate into. And I think it's been mentioned previously, in case of disputes, patentees must provide a full translation of a patent in an official language of a member state where the alleged infringement took place or where the infringer is domiciled. So is the unitary patent beneficial? And I put that as a question. So for large corporates that like to validate European-wide, then yes, it is. It'll be a lot cheaper. But for SMEs who generally only validate in a few countries, less than 5, then the cost of using the entry system will be increased, so not so good for smaller companies. Renewal fees are also, at the moment, as you know, you pay renewal fees to each of the patent offices that the patent is validated in. The proposal is that one renewal fee will be payable to the EPO, and the EPO will divide the fees up to the various offices, and the renewal fee is again proposed to be about 5 times the average cost of a renewal fee. So that would be beneficial for larger companies that validate European-wide, but not for the smaller ones. So that was the process to get the patent to grant. Now I'm going to talk a little bit about the proposed court structure. So diagrammatically, the Court of Appeal will be based in Luxembourg, part of the ECJ, and we'll have courts of first instance, which are local or regional divisions in each member state, and there will be central divisions in Paris, London, and Munich. And the central division, the split of work, will be Munich, I believe, is getting the engineering applications. Paris will get the electronics and software. London is biotech, pharmaceuticals. So court panels are multinational. There will be one legally qualified judge for first instance courts where the parties agree, if the parties agree, and also technically qualified judges for the scientific aspects if they are required for particularly complicated cases. There are local divisions for each contracting states, but some states are able to form regional divisions if they agree. As I said, the central divisions are in Paris, London, and Munich. The general rules are that infringement actions against foreign, so non-EU defendants will be heard in the central divisions. Infringement actions against EU defendants will be heard in the local divisions. And invalidity actions will almost always be heard in the central divisions. So there is a possibility of bifurcation where you might have an infringement action heard in one court, but the revocation action heard in another court. And obviously there are some problems with that. People are saying that, for example, if generics want to launch their products but they're injuncted because of infringement, then the validity of the case might not be heard for a while later, and by that stage their competitors have got the commercial edge. Local or regional divisions have jurisdiction over actual or threatened infringement that takes place in a country, in a country or countries of the division, or where the defendant or one of the defendants has its residence in a place of business in the country. And they also will use the local languages unless the parties agree otherwise. So what I've done here is list some actions that will be heard before the local or regional divisions. I want to speed things up a little bit, so I don't propose discussing each of those, but there's a list of them. central division will have exclusive jurisdiction over standalone revocation actions, and that includes revocation from bifurcating courts, as I've just discussed. They will also have jurisdiction over matters which do not relate to infringement, and these are listed there. Timescales. So the EPO has indicated that they hope to be granting unitary patents by the spring of next year, and I think that's very ambitious, given that the books for agreement, 13 states need to agree the proposals, and in order for that to be agreed, the treaty needs to be agreed on the court structure and how the court will operate, and it's not decided yet what the court rules will be and also what the fees will be. So I'll be surprised if all 13 countries will agree within the next year on those rules, such that the EPO can start granting patents by next year. So what is outstanding? There is discussion on the competence of the ECJ, which will be the Court of Appeal in Luxembourg, as to whether it is competent at handling patent matters. It's not known as a patent court. The budgetary arrangements are not agreed. The single renewal fees are thought to be about 5 times the average for a renewal fee at the moment. The validation costs are about the same figure, and as I just mentioned, the court procedural rules are not agreed. And will these be finalised in the next year? I am not so sure. So in terms of the litigation side, so we're talking about post-grant, there are options to opt out of the UPC system. So the proposal is that for a transitional period of 7 years from when the UPC comes into effect, parties can choose whether to. So the UPC has a non-exclusive jurisdiction over EPC granted patents. So the applicant can choose for 7 years to prosecute it as they would nationally, or choose the unitary court. But and those 7 years can also be extended for another 7-year period, possibly. And thereafter, the unitary court will have exclusive jurisdiction over unitary patents and also patents granted under the current EPC system. But if your application was filed before entry into force of the UPC, then there is an option that the patentee can opt out, and that might be he might want to do that given that the court is untested as yet. But he can also choose to opt in if he wishes, so it's very flexible. And if there are serious doubts about whether the running of the court, then of course the applicant can choose to opt right out, as I've called it, and particularly those applicants with exclusively local operations may wish to file national applications, and the unitary court will not have jurisdiction over national patents. So if costs are no issue, then for maximum flexibility, it might be advisable to file a European application and corresponding national applications with different scopes of claims, just so that the flexibility can be obtained for which court they wish to proceed in later. Which leads me on to some strategies. So as I've said, file national applications, so keep priority applications alive when you file your PCT and then your European applications. Remember you might need to validate in non-EU countries, because some countries party to the EPC are not part of the EU. Applicants might wish to, although it's a big ask, I know, locate R&D or distribution or first launch in a non-bifurcating country to avoid those problems. File applications in English. So you can choose your second language, which is not necessarily German or French, but a language where in the future you may foresee that there might be some litigation in a particular country. Then you might wish to reduce your costs by filing your translation then. And I foresee that EPO oppositions are likely to be more important, given that that system is well tested and you're able to knock out a patent across the whole of Europe in one go by that route. And that's it. Thank you very much.